1946 up to August 1951 and 71% in the 1952 bar examinations. The Supreme Court struck down the law as unconstitutional. In his ponencia, Mr. Justice Jokno held that the disputed law is not a legislation. It is a judgment promulgated by this court during the aforecited years affecting the bar candidates concerned. And although this court certainly can revoke these judgments even now for justifiable reasons, it is no less certain that only this court and not the legislative nor executive department that may do so. Any attempt on the part of these departments would be a clear usurpation of its function, as is the case with the law in question. The venerable jurist further ruled, "It is obvious, therefore, that the ultimate power to grant license for the practice of law belongs exclusively to this, and the law passed by Congress on the matter is of permissive character, or as other authorities say, merely to fix the minimum conditions for the license." By said ruling, the Supreme Court qualified the absolutist tone of the power of Congress to repeal, alter, or supplement the rules concerning pleading, practice, and procedure, and the admission to the practice of law in the Philippines. Thus, if the Congress does not have the power to amend the rules of court under the 1987 Constitution, by parity of reasoning, this court does not have the authority to disregard the rules promulgated by the Supreme Court in the exercise of its constitutional rule-making power. Respect should be accorded to the rules promulgated by a co-equal branch of government, as Congress expects the same treatment from other branches of government. For instance, the Congress under the Constitution has the power to determine the rules of its proceedings. What stands out from jurisprudence on the subject is that, except for some limitations on details found in the Constitution itself, there is a clear recognition of the overall autonomy of the legislative body, both in the formulation and in the application of its rules. The power to make rules is not one which once exercised is exhausted. It is a continuous power, always subject to exercise by the House and within the limitations suggested, absolute and beyond the challenge of any other tribunal. The absolute control which Congress has over its rules is well illustrated in the case Osmeña Jr. versus Pendantun. The Supreme Court in no uncertain terms declared therein, on the question whether delivery of speeches attacking the chief executive constitutes disorderly conduct for which Osmeña may be disciplined, many arguments pro and con have been advanced. We believe, however, that the House is the judge of what constitutes disorderly behavior, not only because the Constitution has conferred jurisdiction upon it, but also because the matter depends mainly on factual circumstances of which the House knows best, but which cannot be depicted in black and white for presentation to and adjudication by the courts. For one thing, if this court assumed the power to determine whether Osmeña conduct constituted disorderly behavior, it would thereby have assumed appellate jurisdiction, which the Constitution never intended to confer upon a coordinate branch of the government. The theory of separation of powers, fastidiously observed by this court, demands in such situation a prudent refusal to interfere. Its department, it has been said, had exclusive cognizance of matters within its jurisdiction and is supreme within its own sphere. It is thus clear that on matters affecting only the internal operation of the legislature, the legislature's formulation and implementation of its rules is beyond the reach of the courts. If this is so, then this court has also no authority to interfere with nor undermine the control of the Supreme Court over its internal rules. The House of Representatives, through one of its prosecutors, has intimated that the principle of separation of powers only applies when the Congress, and in this case the Senate, is exercising its legislative functions, but not when it is sitting as an impeachment court, inasmuch as it has the sole power to try and decide impeachment cases under the Constitution. This court, however, is not yet ready to accept the prosecution's contention. It must be pointed out, while the House has the exclusive power to impeach and the Senate has the sole power to try and decide impeachment cases, it is still the Congress, one of the three branches of government, which is exercising this prerogative under the Constitution. Hence, whether it is performing a legislative function or sitting as an impeachment court, the Senate is not insulated from the operation of the principle of separation of powers. As held in Santiago versus Sandigan Bayan, the doctrine of separation of powers simply means that each of the three great powers of government has exclusive prerogatives and cognizance with its own sphere of influence and effectively prevents one branch from unduly intruding with the internal affairs of either branch. This has to be so in order to maintain the balance of power among the three branches. This is to prevent the aggrandizement of one branch at the expense of another. This will enjoin one branch from lording it over the other and prevent too much concentration of powers to only one branch. Wherefore, in view of the foregoing, the prosecution's request for subpoena duces tecum and ad testificandum to Martin S. Villarama Jr., Maria Lourdes P.A. Sereno, Bienvenido L. Reyes, and Presbitero J. Velasco, all associate justices of the Supreme Court, is hereby denied. So ordered, February 8, 2012, Pasay City, signed Juan Ponce Enrile, presiding officer.
The gentleman from Misamis Oriental.
Thank you, Mr. President. I concur in the result because the resolution is very specific as to the application for subpoena regarding Article 3 concerning the FASAP case. However, Mr. President, I have reservations regarding the statement in the early part of the resolution where the essence I get is that the Supreme Court is a co-equal of this impeachment court. So therefore, Mr. President, I want to study this matter further and reserve the right to file a separate concurring opinion. Thank you, Mr. President.
Noted. The gentleman from Bukidnon.
Thank you, Mr. President. Mr. President, I concur in the result also, and but I do object to the use of the concept of co-equality. As I earlier manifested, I do not believe that this court, sitting as an impeachment court, is a co-equal of the Supreme Court, because we are not exercising legislative functions here. We are exercising a special, specific judicial function. Thank you,
Noted.
Mr. President.
The gentleman from Pampanga.
Thank you, Mr. President. Mr. President, likewise, I concur as to the result. And considering that we are doing pioneering work here in terms of legal precedents, and that what we do and decide and the rulings of this court will serve as basis and guide for future courts, should there be impeachment proceedings in the future, I would like to manifest that I too would like to file a separate concurring opinion. Mr. President.
Noted.
Mr. President,
The minority floor leader.
Sir President, I too concur with the ruling of the court and of the presiding officer, the Honorable Senate President, but same manifestation as my colleagues. And I concur as to the application of this ruling to this specific case, meaning I'd like to elaborate that there can be circumstances where the records of the Supreme Court can be looked at, but I will not elaborate at this point in time, Mr. Chair. Thank you.
Noted. The senator from Taguig.
Mr. President, I'd just like to put on record that during the deliberation on this resolution, my understanding when the presiding officer was speaking on this particular statement, that precisely we are respecting the internal rules, because to that extent we all have our internal procedures, and we respect that the Supreme Court is supreme in their own territory as we are supreme in ours. So to that extent, I am totally supportive of this resolution, because that is the understanding that I believe was intended during the caucus. Thank you.
Thank you. Noted. What's the pleasure of the Chief Prosecutor?
Your Honor, I just want to manifest that the other witness is here today pursuant to the subpoena that commanded her to appear February 8th, today.
Who is that witness?
The witness is the branch manager of the BPI Ayala branch. But if we are adjourning tonight, may we just request, Your Honor, that that BPI branch manager, the name is Miss Leonora Dizon, be directed to appear, to come back tomorrow, 2 o'clock in the afternoon.
Ms. Dizon is hereby ordered, not only instructed, but ordered to appear in this court at 2 o'clock tomorrow afternoon to answer questions if she wishes to answer those questions.
Thank you. Thank you, Mr. President.
It's ordered.
Thank you. Mr. President, may we ask the Sergeant at Arms to make an announcement?
The Sergeant at Arms is directed to make the announcement.
Please all rise. All persons are commanded to remain in their places until the Senate President and the Senators have left the session hall.
Mr. President, I move that we adjourn until 2 o'clock in the afternoon of Thursday, February 9, 2012.
Is there any objection? The chair hears none. Therefore, the trial is hereby adjourned until 2 o'clock